Hi friends, welcome back to my channel. This is Durbadal and today I plan to talk about the basics of contracts. Today we will try to understand what is contract in very simple language. Contracts are critical business tools. At the heart of most professional relationship is a contract. Even if you do not sign $1 million deal or even if you're not negotiating a contract, you touch contract every day in various forms. So let's understand this better. In the simplest definition, contract is a promise enforceable by law. Now, we may wonder, what should we call it? Contract or agreement? Many of us think they are same, but if so, why do we have two different words? So what is the difference? Is there a difference? Yes, there is a difference, and that is the aspect of enforceability. An agreement is the meeting of two minds to a common intention made with an offer and an acceptance. A contract is an agreement enforceable by law. So the question now is how to understand if an agreement is enforceable by law. For us to understand that, we have to understand the basic elements of a contract. First one is offer. All contract starts with a desire. So, for example, I want to purchase a villa. I approached the owner of the villa and I asked him, I'm interested to buy your house. Do you want to sell for, say, $600,000? That is an offer. So, my communication of my desire is the offer. Next, acceptance. Once the offer is presented, the offeree can decide whether to accept or reject the offer. This can result into counteroffer or acceptance. In real world of commerce, reaching acceptance may take some time. Let's continue with the example that we were just talking about. When I met the owner and asked him whether he wants to sell the house, he told me he may, provided whoever purchases agrees to pay $1 million and accepts the house in its current condition. So this becomes a counteroffer and not an acceptance. After listening to the owner's statement, if I reply to the owner stating, I agree with your terms, that will constitute an acceptance. The next factor is consideration. Consideration includes the value that has been agreed upon, whether that be an action or an item. Money, property, services are all examples of contractual consideration. It is important to note here that the value of the consideration is not a deciding factor of whether the consideration is valid. Even an agreement for exchange of service is a sufficient consideration. So, with the same example that we were discussing, the $1 million, which the owner quoted as the price of the property, which I agreed to pay, is the consideration. Now, that could have been a different value. It could have, in fact, been $1 as well. Even that is a valid consideration in the eyes of law. The next factor is legal capacity. This basically means that we cannot contract with a minor or someone who has a mental disorder or is under influence of drugs or alcohol or someone who doesn't understand the language of the contract. For example, I agree to pay Mr. X $100,000 in exchange of his land. This contract would be valid. The only problem is that Mr. X is a minor and cannot legally enter into a contract. So this contract is a valid contract from my point of view, but is voidable contract from the point of view of Mr. X. So as and when Mr. X becomes a major, he may or may not agree to the terms of the contract. Let's talk about something different in current context. In a company, we must remember that every employee does not have the legal capacity to bind the company into a contract. Only employees who are authorized by the company to do so have such capacity. Next factor is legal objective. A contract for an illegal action or product cannot be enforced. For example, Mr. Y agrees to sell drugs to Mr. Z. Although this contract probably has all the essential elements of a valid contract, it is still illegal. So broadly, these are all the essential elements of a contract: offer, acceptance, consideration, legal capacity, and legal objective, which amounts to a valid contract. Broadly, there are four types of contracts on the basis of the formation of contracts. First, verbal contract. Verbal contracts are formed by oral communication. This probably is the oldest form of contracts where both the offer and the acceptance are verbal. Next is written contracts. This is what we mostly see today. The contracts that we deal with, or we negotiate, or we sign, are all in written form. Implied contract. An implied contract is based on the actions or gesture of the involved parties. For example, in an auction, raising the number paddle by the customer is an implied offer, and the final bang of the gravel by the auctioneer when the product is sold signifies that the offer is accepted. The next one is electronic contract, which is pretty common in today's age of e-commerce. A consumer using an ATM to withdraw money is an example of electronic contract. Now let us understand why we need contracts. To understand this better, I think it'll be good if we are able to look into the history of contract law. Contract law is the product of business civilization. As per Britannica, in ancient society, transactions used to happen with the notion of property rather than of promise. In most cases, the transactions used to complete on both sides at the same moment. For example, barter system. Even if the goods exchanged were later found defective, those were handled in various other ways. For example, spoiling the other person's property. There used to be credit transactions as well, but even for such transactions, there used to be other forms of security, like debt slavery. The true need of contract was felt when the society found the value of a commitment or promise. One person seeking a commitment today for a future action. As mentioned in Britannica, probably the first official recognition of contract law happened in 6th century CE, the Roman law of contracts as found in the Byzantine Emperor Justinian's law books. By the 13th century, merchant courts had been established at the international trade fairs. 12th and 13th centuries witnessed developments in contract law both in Europe and England. Since then, the laws of contracts has evolved with time, and as a result, today we have such robust and clear contract law in almost every jurisdiction across the globe. So, what are the benefits of a written contract? First, clarity in business relations, agreements, and rights of parties, because it is in writing which can be preserved and referenced later. Avoiding potential contract disputes and litigation, because both parties have spent time to clearly set out their rights and obligations and the various possible events and the related possible outcomes in the contract. Preventing misrepresentation of communications and agreements. As the contract documents the understanding between the parties, this is very much possible, and the possibilities of misunderstanding reduces to almost zero. Protecting intellectual property, tangible property, and assets value. Because contract spells out specific clauses offering such protection. Better management of commercial relationships. As with contracts, the possibility of disputes or misunderstanding reduces. Easy dispute resolution. because there is built-in agreements about resolving disputes through arbitration, mediation, or court proceeding. Now, all of the above helps in minimizing risks, thus resulting in maximization of profits. Now, since we mentioned risk here, let us understand what is a risk. The dictionary definition of risk is a situation involving exposure to danger. In my opinion, in terms of commerce, risk is a situation involving loss of money, credibility, and business, or violation of law. We also recognize the fact that there is no success without risk, which means if you have to do business, you need to take risk. So how do we take a risk? We need to measure the risk and take calculated risk. When I look at a risk, when I'm reviewing a contract, there are two things that I consider. First is the impact or the consequence of the risk. Second, the likelihood of the risk, the possibility. Now let's take an example. This is a hypothetical scenario. Let me talk about probably a contract which maybe I'm reviewing in 2020 during the times of COVID. Now let's take this example. I'm working on this services contract where my consultants are working from home. It's probably a software implementation contract, and my consultants are working from home due to the COVID-19 pandemic. My customer is located, suppose, in Australia, and my consultants are probably spread out in various other locations, say, India, Philippines, and Malaysia. The customer states that customer will only pay us the hourly fee for the services provided by my consultants and will not pay for any expenses to travel or to live in Australia. So let me analyze this situation. The impact first. So the impact can be huge because if my consultants are really traveling from their home location to Australia, the travel cost will be huge. At the same time, living in Australia and working for the client would also add to the cost. So the impact can be pretty large. Now let's talk about the likelihood. Travel at the time of 2020 was actually closed internationally because of the pandemic. So the possibility of a travel probably happening in the next 6 months from 2020, when the time I was probably working on the contract, was close to zero. So the likelihood of that thing happening is very less. How can we control this situation? We can control the risk by probably stating in the contract, after discussion with the customer, that the work will be done remotely and any need to travel will be discussed and agreed with the customer separately. So we recognize that there is a risk because there is an impact if that situation happens, but the likelihood of that risk happening is very less, and we're able to control that risk by putting in necessary language in the contract that we are working on. So this is just an example, and there can be other scenarios, other risks, and for every such scenario, although we need to deal with those on case-by-case basis, but the principle of how we look at a risk will always probably remain the same from my perspective, is first analyze the impact, then the likelihood, and then finally how to control or mitigate the risk. So finally, we understand that calculated risk is the way of trade. If we have to do business, we certainly have to take risk. But if we are able to analyze the risk and take calculated risk, it will certainly lead to a successful business. Thank you for watching. Hope you like the video. If you have any questions, let me know in the comments below. Please do take care of yourself and see you soon in the next video.